All right, well, good morning, everyone. I do hope everyone can see and hear me properly. We've got a good number of attendees so far, and I'm sure a few more will join, and we'll pick things up as we go along. Welcome. My name's Simon Pedley. I'm a partner in the disputes team at Mills and Reeve, and this is part of our in-house In Focus series of talks. More traditionally, we do these as face-to-face seminars in our various offices, and we got a couple of them done before we were all sent to live at home for the indefinite future. So we're doing the further talks by means of webinars today and the next couple of days with some new topics as well. So today you've got me talking about legal privilege, and I'm absolutely delighted that so many of you signed up for this and are attending. So I do hope you find it useful. It should be about 40 minutes or so. Just a couple of things. Everyone has been muted, and because of the numbers during the talk, there won't be a lot of opportunity for, as it were, face-to-face discussion and questions. You should notice, though, that though the chat function has been disabled, there is a Q&A function. So if you do have questions that occur to you during the course of the talk and you want to raise them at the end, then please do so, and I'll take a minute or two to review what questions we've had, and then we can discuss it. And also at the end, I'll hang around for a little while after the seminar is finished, so if anyone wants to stay online and have a face-to-face discussion about anything, then that would be absolutely wonderful. I'll also say, and I'll try to remember to say again at the end, please use that Q&A function at the end for giving any feedback, and particularly any ideas for topics you would like covered in the near or medium term, since I'm sure we'll be doing more of these webinars. This is our first one we've done, actually. So many thanks to our marketing and IT teams for helping sort all this stuff out. Any failures in delivery are entirely down to me, not to them, I assure you. And this is the point of these talks, when I normally say there's no fire alarm plan, so that if one goes off, I point you to the exits. None of that today. If you hear an alarm, that's entirely your own business, and run and get out in whatever way seems appropriate to you. I should also say we've had one question in advance was sent in by Bethan Power from Manchester City. I don't know if Bethan has joined yet, but she was wanting to deal with the point that, as she is aware, only certain internal stakeholders with a certain level of seniority who are authorised to request and receive advice can benefit from legal advice privilege. Are we going to cover that? Yes, indeed, we are going to cover that. So let's see if this screen sharing works. Now, hopefully, therefore, you can see that, the introductory slide. So what are we going to cover today? Well, okay, moving from slide to slide is not happening as I wanted. There we go. Okay, use a different keyboard. So the aim of today is to remind everyone what legal privilege is and when it applies. We'll try and liven it up with some case studies. I'm going to hopefully give you some tips to enable you to help ensure that privilege applies and how to stop losing it, because privilege could easily be lost. And also, I particularly want to give you some ideas as to how to bring this topic to life for your boards and for your senior management in your organisations. And I think this last point is crucial. In my career, I've seen a lot of examples where the non-lawyers often think that privilege, what does this mean? Oh, disclosure of documents, we'll just disclose what's relevant to our case, what we want to disclose, that's all. And people aren't necessarily aware of what they may have to search for and disclose in the context of litigation or regulatory investigations and so forth. They just have a sense that they'll disclose what they want. Well, that's, as we all know, very much not the case. And if you have people in your organisations who happily fire around WhatsApp messages to one another without appreciating that they're creating potentially disclosable documents and talking about sensitive things, which may well not be privileged, then hopefully I'll give you some ammunition to help keep them on the straight and narrow. And the big issue big issue of privilege from my perspective as a disputes lawyer is that it's only looked at really after the event, and you're looking back and scrutinizing things in the context of litigation when no thought possibly was given to whether privilege applied at the time the event happened a number of years before. So your role as in-house lawyers is particularly crucial in helping preserve privilege for the benefit of your organization. So legal privilege, what is it? Why does it matter? Well, a couple of quotes there, both from the Law Society. Legal professional privilege protects from disclosure of confidential communications and material evidencing such communications that take place between clients and or their lawyers, and in some circumstances also between clients, lawyers and third parties. It's one of the highest rights recognised by English law. It has existed for over 400 years and is treated under English law as a fundamental common law right and as a human right. And so the key point is that if privilege applies, it entitles a party or its successor entitled to withhold evidence from production when otherwise it might be required, and production to a third party or to the court. And that can be written evidence or oral evidence. And obviously, as I say, privilege is most usually seen in the context of litigation, but it also has to be considered in other forms of inquiries or regulatory actions and so forth. So then, what types of privilege are we going to be looking at? Well, legal professional privilege in its two flavors, legal advice privilege and litigation privilege. And briefly, and if we have time, we'll look at without prejudice privilege and common interest privilege. Just bear with me a minute, I had a couple of questions already. I just want to check that these aren't saying, yeah, fine. These are all things which will be dealt with. I'm just checking that no one was saying I can't hear you or anything like that. So I'll plow on now, plow on regardless. So we'll deal first with, now for some reason it has my screen. There we are. So legal advice privilege then, what does it cover? It covers confidential communications between lawyers and their clients made for the dominant purpose of seeking or giving legal advice. And it's an absolute right and it's a substantive right. So it's clear it covers a hugely broad range of things. It protects you from having to disclose documents in the context of litigation, but also in the face of certain requests from public authorities like police or the tax authorities or Competition and Markets Authority or the Charity Commission or whoever it may be, unless there is very clear statutory provision to the contrary. And there are very few statutes which do override privilege. Regulation of Investigatory Powers Act 2000 is one of the few that does. And even where a statute does appear to override privilege, the courts construe this very narrowly, and we'll see that privilege is often still held to apply. And so the statute has to be really clear. And there was a recent case of that. It was JSC, BTA Bank and Ablyazov, 2012. There were lots of decisions in this case, and this was, I forget which country, it was one of the former Soviet states and a corrupt oligarch, allegedly. And he was facing contempt of court proceedings. He was not in the country, wasn't coming in, wasn't telling anyone where he was, but he had instructed lawyers and they were going there. And the other side applied for disclosure of email details, phone number, those sorts of things. And they thought there was an exception to that. And the judge held no, even that information was privileged. That was confidential between them and the lawyer. So they couldn't find out where he was. And there was a very recent case, actually, Sports Direct International and Financial Reporting Council, that was just this year, where the Court of Appeal held there that the regulator's statutory powers didn't override the privileged status of documents, overturning a first instance decision which held that it did. But going back then to the definition, there are a number of elements there which are important. And the first one is confidentiality. There has to be confidentiality in the document or the communication to attract privilege. And a few things which aren't confidential and therefore don't attract privilege. These include any transcript of proceedings in open court. If you're there for your business and you're taking a note, that note isn't privileged. Attendance notes you take of a meeting where the other side are present, those aren't privileged. And similarly, any attendance note you take of a telephone conversation with the other side. The only slight exception is if it contains additional notes from you. So if, for example, it says, speaking to Bob from the other side who said he wanted this warranty for this reason, and then square brackets, haha, the idiot, he's missed this big point. I think we've got what we want here, close square brackets. Your little aside might be privileged and might be redactable if the document has to be disclosed. But that, if that's the only record of the conversation, if Bob on the other side hasn't taken a note, your note may be a disclosable document, even if it goes against you, and it will not be privileged. And another very important element is this one of the dominant purpose. Now, this is a very recent clarification of the law around legal advice privilege. In litigation privileges, we'll see we're used to thinking about what is the dominant purpose of the creation of the document. But the Court of Appeal in Civil Aviation Authority against the Queen on the application of Jet 2 Limited, it's a judicial review case from end of January this year, has confirmed that seeking or giving legal advice does have to be the dominant purpose of the document if privilege is to attach to it. And this was a clarification of a difficult area of law. And what Lord Justice Hickinbottom said was, whilst I readily accept that the jurisprudence is far from straightforward and the authorities do not speak with a single clear voice, I consider Justice Morris was correct to proceed on the basis that for legal advice privilege to apply to a particular communication or document, the proponent of the privilege must show that the dominant purpose of that communication or document was to obtain or give legal advice. And he said this about where a document has multi-purposes and multi-addressees. Where there is a multi-addressee email seeking both legal advice and non-legal, e.g. commercial advice or input, if regarded as separate communications, those to and from the lawyer will be privileged. Otherwise, they will not be privileged unless the real dominant purpose of a specific email to or from non-lawyers is that of instructing the lawyer. If it is not for that purpose, in most cases, the email as a whole will clearly not have the dominant purpose of obtaining legal advice. So for your organizations and for your senior management, what everyone has to be wary of is single emails which seek from multiple recipients, both non-legal advice and input and legal advice, because you could easily find that the whole thing isn't privileged. So a potential tip here, if it's on a sensitive matter, clearly you won't do this for everything, but if emails have to be sent to multiple recipients from someone within the organization, consider structuring it so that the email is addressed to you as the in-house lawyer and only CC to the other recipients, and have it stating at the head, this is a request for legal advice, even if it then branches off into other things, because practically it'll be more easy to defend your claim to privilege if it's got that sort of wording in it. And similarly, this goes for minutes of meetings as well. If there are legal and non-legal bits, the whole thing isn't for the purpose of obtaining legal advice, then the non-legal bits certainly won't be privileged. It has always been the case, and it remains the case, that if you have a document where one bit is non-legal, one bit is legal, and they're clearly delineated, when you disclose the document, you can redact the legal advice section. And did this recently on a case where lots of board minutes had to be disclosed, but section 1, 2, 3, 4, and number 5, legal, you leave in the heading and then blank out the rest of the section, so the other side can see that it is just the privileged bit that you're redacting. But you do have to be very careful with these documents that are for multiple purposes, and this is a recent change and clarification to the law. So then we come on to the question, well, who is a lawyer for the purpose of privilege? Well, certainly is the obvious members of the legal profession, solicitors, barristers, including in-house employed solicitors and barristers, foreign lawyers, legal execs and licensed conveyancers who are employed to give advice on English law by a licensed body. It also covers the employees of those people as long as they're properly supervised, etc. It's in fact not totally clear whether a lawyer without a practicing certificate, whether privilege attaches to his or her advice. It probably does, unless the reason the solicitor doesn't hold a practicing certificate is because of their own professional failings, e.g. if they've been sort of struck off or reprimanded or suspended or whatever it may be. But that's probably not relevant to you as an audience. I mean, I had a case once where the opponent on the other side was taking advice from a dodgy, struck off former lawyer, and we successfully argued that they had to disclose the entire file of documents between them. given that the opponent and the legal advisor were both totally dodgy. We only, in the end, got about 2 unhelpful pieces of paper from that process, but the point was there. And in European Commission competition law investigations, as in-house lawyers, you may know, that's always been an exception in that communications with external lawyers will be privileged, but communications with in-house lawyers won't be. That's the Axo Nobel case. Post-Brexit, whenever all the withdrawal agreements end, I suspect that's one less thing for us to worry about. But what about other professions? Well, basically, no, hard luck, and particularly hard luck accountants who have tried on many occasions to argue that where they give advice on legal matters, generally about tax, that should be privileged. And that's been confirmed in the Supreme Court in the Prudential and Special Commissions of Income Tax case in 2013. So very few exceptions, patent agents in some limited circumstances, but really it's us as lawyers and the other professions don't get this benefit. The privilege belongs to the client. It cannot be waived by the lawyer, externally or internally. It is the privilege of the client, the individual, or the organisation itself. And then we come on to the thorny question of who is the client, and this is the question that was raised beforehand by the lady from Man City. And we go to Three Rivers, number 5, whole series of cases on this. We won't go into the facts of what the underlying dispute was about. This was particularly about legal advice privilege, but the same point as to who is the client has been confirmed in the context of litigation privilege as well in a separate case. And this is a case which I think will be relevant to a lot of you, where the client instructing the lawyer is some sort of corporate entity and the advice sought is non-contentious. And the Court of Appeal decided that the client, for the purpose of engaging in such corporate communications, is not the corporate entity itself, which is a legal fiction. Corporate entity has to act via individual agents. But they said it was the narrow group of individuals employed by that entity who are expressly charged with seeking and receiving legal advice on the corporate's behalf. In that case, there was a little unit set up within the Bank of England called the Bingham Inquiry Unit, which was tasked with the liaising with the external lawyers. And the court held only that unit counts as the client. So that means that only those charged with seeking the legal advice who can engage in protected communications with the lawyers, the external lawyers in that case. And others within the entity who may make any sort of communication, whether that's internally or whether that's to the lawyers themselves, they run the risk of engaging in communications which aren't covered by privilege, which have to be disclosable in subsequent litigation. Now, this reasoning is a complete pain in the neck for everyone. We all know it is, and it has been doubted in cases, including that Jet2 case I mentioned recently, but it remains the law, but it doesn't reflect the reality of how things are done in a large organisation. Now, I'll just pause for a moment because a couple of people have raised their hand. I'm not sure there's a few questions there. I'm sorry, the specific questions, just with the numbers, I probably can't answer specific queries and points as you raise, and we will try to cover everything you want to say at the end. So apologies if you have something very pertinent, helpful to share. I'm sure we'd love to hear it, but just the practicalities of managing this process, I'm afraid that's slightly beyond me at the moment. So how do we deal with this problem then? There are a couple of schools of thought. One is that at the start of, it'll only be a major sensitive matter, that you should define there and then who is the client. You 10 people are the client, and you're the only ones who can make privileged communications with the lawyers. There's a risk that the court won't accept what you define as being the client for those purposes, and they may hold that that group is in reality smaller, or indeed you may realise that in fact who you defined the group as isn't what you wanted, and it turns out that someone else outside the group is who really needs to be communicating with the lawyers. So there are dangers in sort of defining it beforehand. The alternative, and I tend to favour this, is address the issue of who the client is only when a dispute on privilege actually arises, and there's a bit more wiggle room there. And in 99% of cases, it's a self-selecting group. Clearly, the people who are communicating with the lawyer are the people who need to communicate with the lawyer, and they are self-evidently the client individuals for the purposes of privilege. But obviously, if it's a big and sensitive matter, more thought is needed. So there's no obvious answer other than just restricting communications to a smaller group as is necessary for lots of good reasons. I don't think you can designate the entire body of employees of an organisation as being the client. That won't work. Unless it's a small organisation, in which case these issues don't apply. I mean, if it's a company with 10 employees, including its directors, then I'm sure they do all count as the client, but not for large organisations. And you can't, much as you would like to try, I don't think it's feasible to channel everything via you as the in-house lawyers. Others may need to engage in privileged communications as well, separately from and parallel to you as the lawyer. And it's impractical to construct this inner client for every issue. But in big transactions, then you'll need to give a bit of thought. The second point to mention, the second tip, is that this only really applies in non-contentious matters. In contentious matters, in threatened or actual litigation, as we'll see, communications with third parties are covered by privilege anyway, so the problem doesn't arise really in the same way. But here's the other tip from a litigation lawyer's point of view. In all litigation, I can tell you, if it is even vaguely reasonably arguable to assert privilege, the starting point is assert privilege and leave it to the other side to challenge. Obviously, you can't assert that something is privileged if it clearly isn't, but if it's got the in-house lawyer copied in and you think you might get away with an argument, even if you don't think you'd win that argument if push came to shove, assert privilege to start with and then let the other lot challenge it. We did this recently for a big case we did for a big sports club client, and it was a horrendous, huge disclosure exercise in a very short time scale, all hands to the pump. And the starting point was anything internal, an internal communication within the client that included the in-house lawyer, CC'd or addressed or whatever. We thought, right, starting point, we'll assert privilege over that. And believe you me, in that litigation, the other side would challenge absolutely anything. They were very aggressive. They didn't, in fact, this was one of the very few things they didn't challenge around the whole process. So starting point, assert privilege, leave it to the other side to argue against you. Now, it's a particularly acute problem for you, for private practice lawyers like me. Obviously, everything of our communications with our clients essentially is privileged. But for you, when you're mixing legal advice work and business advice administration work, that's more tricky because that business advice administration won't be privileged. So in as far as you can, try and separate the two and do the legal stuff in separate communication. And if you can, mark it legally privileged. I know real life, isn't necessarily like that, but on those bigger and more tricky matters, those higher risk matters, high value matters, try and do that. And also I'd suggest you give your board and your senior management some appropriate training. Keep it simple, keep it capable of being followed, and maybe a one-page list of do's and don'ts. I've got one of those pages later in the slides, which will be circulated afterwards, so you can see an example. And as soon as anything big or sensitive arises, a potential problem, it's down to you to raise the issue of privilege at the word go, because no one else will be thinking about it. And if you don't, you might find that a whole host of sensitive, important stuff loses privilege, doesn't attract privilege in the first place. And get yourself copied into sensitive things. I mean, it's not the answer to everything, but if you're copied in, it's much better and easier to assert privilege than if you're not. So we'll come now on to an example scenario, and if the technology works, I will launch a poll shortly to see what you think. This slide is, for some reason, not moving on. Again, I don't know if Sarah in the background, you can move it on for me. It appears to have stopped, which is, there we are. Whether that was me pressing the button multiple times or Sarah in the background helping me, thank you very much. So here's the scenario. Got a publicly quoted client, and it's in a bit of bother, and it's considering whether it might need to issue a profits warning. But it decides not to. And as part of this decision-making process, firstly, it gets an internal report from its FD as to what would happen, like if trading was down 10%, and what would happen if this, that, and the other, to give us the numbers. You've also got directors circulating WhatsApp messages between themselves, and they go externally to the company's broker to get its view on what has to be disclosed to the market. And then they come to you as the in-house lawyer and seek your advice. And then there are board meetings and so on. And then let's assume there's subsequent litigation from a disgruntled shareholder who invested, then the profits were much worse than anticipated. And he says, well, you should have issued a profit warning. I wouldn't have invested if you had done your job properly, breach of duty sort of claim. And the question is, are any of these documents disclosable? We can't quite have the chat that we'd have face to face, but let me see if I can launch the first poll. So on your screens, just give us your view on whether you think that FD's report is privileged. Excellent. I see we've got 181 people on this call now, so this is great. The votes are going up. 113 so far. Excellent. Okay, well, there you are. That we've probably got enough of a snapshot. I hope you can see it. What it's reading at the moment is that 13% say yes, it's privileged. 80% say no. 7% in fine legal tradition are saying it depends. Interesting. Well, there's the end of the. Oh, sorry. There, that's what I do. I end the poll and I share results. So hopefully now you can see where we got to. I agree with the majority. I think in this case that as always, there's a bit of it depends. In this situation where the FD has just been asked to look at the numbers, run the numbers, do a report on our situation, that's not a kind of confidential communication between lawyer and client or for the purpose of getting legal advice. It's for the purpose of looking at the finances of the company. So it's created in unprivileged circumstances, I think, pretty clearly, and it doesn't become privileged simply because it is subsequently required for seeking advice from you as the in-house lawyer. That subsequent action doesn't turn the unprivileged original document into a privileged one. Even if it had been prepared after a decision had been taken to get your advice as in-house lawyer, it's probably still just an internal client communication and not a privileged document, and thus not privileged. And I think the same thing happens with the communications externally with the broker. That's not a solicited client communication, even if it's sent by you as the in-house lawyer. So that communication, those discussions, those documents wouldn't be privileged from subsequent disclosure. And certainly the director's WhatsApp messages are likely, very likely, not to be privileged. They're not, again, confidential solicitor client communications, and it's unlikely you'll be able to argue that they are for the purpose of instructing you as the in-house lawyer. So involving you after the event doesn't help. When you get some board minutes, as it said, well, you want to keep those, structure it so that the legal bit is very much separate from the other bit, because then we've got this, otherwise we've got this mixed document which may or may not attract privilege. So to give yourself a chance of privilege, make sure you're involved at all stages as much as possible, and deter your senior executives from casual communication. Now, again, I'm trying to go to the next screen, which isn't working. So again, if, there we are. So we turn now to litigation privilege. This is a communication between a lawyer and a client, or between either of them and a third party, albeit a document created by or on behalf of the client or the client's lawyer, made for the dominant purpose of litigation, dominant purpose again, and related to litigation which is pending, reasonably contemplated or existing, and again, has to be confidential. I think the key questions here then are what does dominant purpose mean, and what is litigation, and when is that pending or reasonably contemplated? Dominant purpose is a test of dominance, not exclusivity, and the court will look objectively at it, and just saying privilege won't necessarily mean it is, but the more you have within a document, this is a document to enable our solicitor to give us advice, the more likely it is that privilege will attach. And if it comes to a dispute on it, if it is challenged, the more evidence you can put in about what everyone thought about the pending litigation and the need to obtain legal advice, the easier it will be to defend privilege. I have to say, I don't think in my career I've ever had anything challenged where litigation privilege has been asserted and either we've challenged on behalf of our client or the other side has challenged it. It's a pretty rare thing, since most of the time it's pretty self-evident when the dispute is brewing and why documents have been prepared. It does cover documents when people decide whether or not to settle. There was a case, WH Holding in E20 Stadium, which at first instance held that emails, messages between the board as to what terms should we settle on were held not to be privileged. These were just commercial considerations, but the Court of Appeal sensibly overturned that and said no. Dominant purpose of conducting litigation includes conducting it in all its aspects, including deciding whether or not to settle and on what terms. But litigation privilege doesn't cover just purely commercial discussions. And then the other question, what is pending, reasonably contemplated or existing litigation? Well, litigation must be a real likelihood. It doesn't have to be more than 50% likely or anything like that. It has to be a situation which could well give rise to litigation, but there has to be some threat of a dispute. You can't claim litigation privilege when you're deciding internally whether to do something, knowing that when you implement this decision, you'll really annoy another party who may want to sue you. That's not pending litigation. So you'd need to rely on legal advice privilege for something like that. And what is litigation? Well, it obviously covers high court, county court litigation, it covers employment tribunals, and it covers arbitrations under English law. It's less clear about other tribunals and public inquiries or things like that. That was around Three Rivers, because one of the first decisions was that this inquiry was just an inquiry. It wasn't adversarial, therefore litigation privilege couldn't apply, or else there wouldn't have been this problem as to who is the client. So if you've got a regulatory type investigation, you'll just need to give some thought to that, and I won't go into any more detail now. I am conscious that we're at 10:35, so I've only really got another 10 minutes or so. So I will move on to the next example. You've got a contract dispute brewing. So you've got significant problems with the performance of the independent company you have in to manage your warehouse, and you have not paid these warehouse managers for a while because of your concerns, but there hasn't been an explicit threat of litigation. An internal review and investigation is done by your senior operations bod to work out what's been going on and to get these people to up their game. And similarly, you've got some external consultants also reviewing their performance and producing a report. So I'll see if I can now launch the next poll. Hopefully this will come up. I'll end that polling. Right, oh, here we are, polling 2. So question for you, is the operations manager report privileged? So give us your votes on that. Votes coming in thick and fast. I will give it another 10 seconds and then I'll end that polling and share the results and see where we've got to. Okay, let's, lots of you have voted, thank you. So let's end that now and let's share the results. So we've got yes, 37%, no, 57%, and the fantastic 6-7% again doing the it depends route, which I heartily approve of. more split than the previous scenario. Yeah, it's partly, it depends. I think it would be, if your internal report is just looking at the poor performance of these people, what are we going to do about these warehouse managers? No one threatened to sue anyone yet. It's tricky to say that that's for the dominant purpose of contemplated litigation, but possibly you could. So I think there's an it depends in there. Strategies to help you claim privilege in it, or anything sensitive like this, is to, in the the memo or whatever to the operations manager, lay it on thick. There's a real possibility of litigation. These people are underperforming. We may have to sue them. We want to consider all the options. Please investigate. Putting that sort of stuff in makes it much more likely that you'll be able to claim privilege. Or, of course, get it all headed up by you as the in-house lawyer, and then it'll be much easier to claim privilege anyway, legal advice privilege, even if litigation privilege is a stretch. Similarly, I think the external consultants, unlike legal advice privilege, in principle here, communications with third parties can be privileged, but with the same issues as for the operation manager's report, it would be difficult. If the letter before action has been received, I think that makes it much easier. If they've written a letter saying we're about to sue you for not paying us for the last 2 months, pay up within 7 days or whatever, then it's much, much easier if you do all these things afterwards to refer to that threat of litigation and to claim privilege. So, but as I said before, as with all litigation, starting point is assert privilege and then wait for the other side to challenge if you properly can. I have got, hopefully, another example, and again, it's taking a while to get on. There we are. I won't, just given the time, I won't go through this scenario now, because I will just want to cover briefly the other things. But this is a situation about potentially losing privilege where you've done a memo of advice on a sensitive issue, which is clearly privileged, but your managing director shares your memo of advice to a third-party employee who's being investigated and his solicitor. Is that advice still privileged? And for the reasons we've discussed, for all these rules, I think there's a real risk you would lose privilege there. And that is based on something that happened with a client of one of my colleagues recently. But I won't go through that, and I won't do another poll now. I will then just briefly go through without prejudice privilege and possibly common interest privilege. So without prejudice privilege, it prevents statements which are made in genuine attempts to settle a case being put before the court. There is a distinction between something which is without prejudice and something which is without prejudice save us to cost. If you make an offer on a without prejudice save us to costs basis and the other side don't accept it, and then it goes to trial, if it becomes relevant when it comes to the court awarding costs after a decision's been reached, you can produce that document and say, you need to take this into account. They've only won 100 grand on this litigation. I offered them 200 grand a year ago. They should pay all the costs. Grossly simplifies the rules and stuff, but that's without prejudice save us to cost. But if it's genuinely without prejudice, it means though concessions made against your interest can't be used against you, which is an exception to the normal rule. If you make an admission against your interest, well, that can be used. There has to be a dispute in existence. I mean, that could be a question of fact, but in most cases it will be pretty obvious. And there'll have to be a genuine attempt to settle. So you can't use a without prejudice heading to cloak other correspondence and assume it won't be seen. When I was a very junior lawyer, my head of department was a guy called Vincent O'Farrell, who was a real old school litigator. And he had great fun in one case where he was a litigant in person on the other side who used to regularly send him correspondence headed without prejudice. Dear arsehole, what I think is X, Y, and Z. And he had great fun responding to this guy and making the point that just marking something without prejudice doesn't mean it's a cloak for abusive material not to be put before the court and all that sort of stuff. So the use of the without prejudice label, as that correspondence shows, is not definitive, but it helps. So if something is intended to be without prejudice, mark it without prejudice. And if the privilege applies, it applies to a whole sort of continuum of correspondence. So if you're having a without prejudice exchange and you accidentally forget to say without prejudice on the top of one of your emails or letters to the other side, if it's part of that toing and froing in settlement negotiations, it will still be privileged. So the label isn't determinative. But as with everything, it helps if you've got it labeled correctly to start with. And the other important point here is the privilege belongs to both sides and can only be waived by the consent of both sides. So just another example, there wasn't a poll attached to this, but parties to a contract are in dispute, and as part of settlement of that dispute, they enter into a new contract to regularize things between them. And all the negotiations for that new contract are marked without prejudice and subject to contract by party A's lawyers. There's a subsequent dispute about the terms of the new contract. Can party B rely on the content of those negotiations when looking at the interpretation of the new contract? Well, we had exactly this issue for a client where an agreement entered into in settlement of a previous dispute itself was disputed, and our client wanted to rely on these documents, but the advice was, no, that's without prejudice. You can't unilaterally waive that. So we couldn't bring in all this this stuff about negotiations. Probably a good thing, because A, most of it was entirely irrelevant, stroke inadmissible when construing the contract, and B, it didn't actually help us in the way that the client thought it did, but that's by the by. Common interest privilege, I won't talk about this, but this is where an existing privileged document can in some circumstances be shared with another party where they have a common interest in the subject matter. So you can often get this between co-defendants in litigation or things like that, but it means the privilege can apply. But I won't cover that now because I am conscious of the time. And couple of points just in passing. Other jurisdictions, be very careful about it. Don't assume that the rules that we have in England and Wales will apply in America or European countries or whatever it may be. Always take local advice because it may be quite substantially different. And privilege in the criminal context, again, I won't really cover this. It's not my specialist area at all. But by and large, if you're thinking I want to do something and I don't want to commit a criminal offence, can you advise me? That advice will of course be privileged. But as you can't take legal advice as part of the conspiracy, as part of the furtherance of the criminal enterprise, and that won't be privileged. And this crime fraud exception has existed for many, many years, since 1884, I think is the case. But I won't cover that further, but it will need looking into. So on to then some do's and don'ts. These will be circulated, but these are some simple do's and don'ts, and this is the sort of thing which I hope might be helpful to the senior non-lawyers within your organisation. Do communicate verbally, not in writing where possible. Route the communications through you. When communicating with you, explicitly state we're seeking legal advice, limit distribution lists, treat everything as confidential, etc., etc. Don't write things down unless you have to. Avoid, when you do write it down, speculation, pejorative language, blame, anything like that. Don't make handwritten notes on documents that may otherwise be privileged. Don't record discussions about the matter in board minutes unless you're very, very careful about clearly delineating it as a separate legally privileged section. Don't discuss with third parties, and don't assume necessarily that things will be privileged just because you say so. So something like this, specific to your organisations, might be something worth reminding your senior management of at the start of any big, sensitive, major contract or other sensitive matter. So final words, I mean, just bear in mind it is sometimes difficult to ensure that privilege applies in the first place, and it is very easy to lose privilege if you disclose something beyond where it's supposed to go. It loses its confidential character, it loses its privilege statement. But this also goes in with the nature of electronic documents these days. Once you've typed an email or sent a WhatsApp or whatever it is, it exists somewhere in the ether. I'm no means of an IT expert, but there are multiple copies of an email. There's one on your phone, there's one on a server, there's one on someone else's server, someone else's phone. It just spreads and proliferates, and searching for and managing electronic documents is a big problem in litigation. So it is better to ensure that the document is not created in the first place. So if you can say it, don't write it down, is the first point. If they're concerned about something, pick up the phone or do a Zoom or a FaceTime, and don't record the Zoom because that creates a disclosable document, but do something like that and discuss it. Don't fire off hard copy documents. If you have to put it in writing, don't put it in an email or electronic message, do it in a memo or something like that where you restrict it. And if you have to put it in an email, don't copy it to anyone who shouldn't see it, and make sure they observe all that confidentiality. You know, plenty of litigation I've seen where documents were just created in an unwise way. And even when things have been said in jest or in a light-hearted way, when looked at on a piece of paper, you think, oh my Lord, this document is disclosable. And I had one case, a professional negligence case, where a managing partner of a law firm made some sort of flippant internal remark about the dodgy client, about, oh, he's got what he wanted, defrauding the bank again, ha, ha, ha. But then this was absolutely central to the other side's case. You knew that this guy was involved in a fraud, and blah, blah, blah. And it was a massive, massive case. And when you see these documents, you shudder. So the more we can encourage our, excuse me, our colleagues and our senior management to do this, or not to do that in particular, then the better. So there we are. That is the end of the talk, and looking at the time, I have just about kept to time. So thank you for bearing with me. I will stop sharing the screen, and I'll have a quick look at the questions on the Q&A. So bear with me just for a moment. I won't speak while I look at see if there's any themes there that I want to cover. So hang on a tick. Okay. So a couple of points. I'll rattle through these as best I can. Does privilege apply to criminal investigations? Yes, unless it's part of furthering the criminal purpose. Yes, if you're advising when someone's being investigated on a criminal matter and you're giving legal advice, then that should be privileged. But I'm not a criminal or regulatory lawyer. Privilege would continue to successors in title, as I had said. So the privilege sort of passes with the business, or successors entitled to a party. Sometimes the privilege can be preserved, even if there's been some sort of change. Someone said, repeat the point about in-house lawyers. I'm afraid I don't know which point that was about in-house lawyers. I've mentioned that a number of times, so speak to me afterwards if I've been unclear, which I'm sure I have. Someone has said, would it include trustees and executive committee, e.g. in a university? And I'm assuming this question means, would they count as the client? Well, almost certainly the trustees would, and that senior sort of exec committee, like a board. It depends on the circumstances, and it depends on what legal advice is being sought on, but those sorts of people you would generally feel pretty comfortable count as the client, come what may, but you can't say definitively for every situation. That question has been from Carolyn Pike. Anthony Cloak has said, I work for an NHS trust. I'm not a lawyer, but sometimes have to seek legal advice on contractual matters. Am I the client? It depends one, but if you are the employee charged with seeking or receiving legal advice, then yes, your communications with the lawyer, whether that's in-house or external, probably would be privileged, because you're the person charged with seeking that advice, impliedly by means of your role. So if that came up in any dispute, I would feel happy in asserting privilege. Then one from Hillary, how does that team then take instructions from the decision makers in the organisation? If that's to do with, if you've got a little unit that's charged with seeking legal advice, but then you would say that the senior bods, the directors, the board, or whatever, would count as the client as well. So if they are tasked internally, the board are saying, you please prepare all this, report to the lawyers, then collectively I think they would all count as the client. Anonymous attendee has said, if a senior person, e.g. an executive director who is regarded as part of a group forming the client, later has a dispute with their employer, would they be entitled to disclose the details of the privilege advice previously received in that role? Or would the employer, who is the ultimate client in respect of the advice, be able to assert privilege in respect to the subject matter? I think the answer is yes. It's the organisation, the company is the client. That the fact that that individual happened to be part of the small group who constituted the client for communications with lawyers, but yeah, the privilege belongs to the client and it's not for the individual employee once he's out in the cold to dispense with that privilege would be my view there. What's the position, someone has asked, on communications between legal team lawyers? For example, we may need to discuss the advice we will give to colleagues and draw on advice or expertise of others in the team to formulate this. We can't always do this verbally, so may discuss the situation and potential advice in writing within the legal team. If it's within the legal team, I think that's absolutely fine. If it's what is produced between the individual and the internal client is privileged, the fact that you then within the legal team seek that discussion, that absolutely would be privileged, I'm sure. Someone has asked, what are your thoughts on the NHS track and trace app and the possible legal privilege implications if any client being tracked while meeting with their lawyer? I've not thought of that issue. I have to say, I mean, there's, other than in broadest and most banal sense, there are clearly lots of privacy and similar issues, but I don't know the answer to that, whether there's that location data that they happen to be in Mills and Reeve's offices on a particular date, does that constitute as privilege? Could do, but it's, yeah, be tricky. I don't know. Emma Wallace has asked, as a forensic accountant acting as an expert, we typically send reports and emails to the lawyers on the basis of privilege in contemplation of litigation. Does privilege also cover internal correspondence between the forensic team when working on the matter? Yes, absolutely. If you're an accountant and you are all constituting third parties communicating with the lawyers, and that discussion amongst yourself, absolutely, that would be privileged. There wouldn't be a problem with that. Someone has asked, as the lawyer, would you suggest not taking file notes of conversations? I'm sure the SRA would require me to say, absolutely, you should take file notes of conversations. But just bear in mind, depending on what that conversation is, it may not be privileged. If it's a party meeting with the other side and yours is the only record, that might well be a disclosable document. If a trainee is offering advice, would this be covered? Yes, it is, provided they're properly supervised. All employees and non-qualified people and secretaries within a legal team, if they're properly supervised as part of the structure, that absolutely is privileged. If information is disclosed under litigation privilege, can this then be used in court? I'm not entirely sure. If it's covered by litigation privilege, it shouldn't have to be disclosed. If, say, within a without prejudice context, a mediation, you disclose information that's without prejudice, then that's subject to the without prejudice privilege and it can't be used. And there's separate rules about documents disclosed normally in the context of a piece of litigation can't be used outside that piece of litigation without court approval. Someone has taken me to task on my advice about criminal investigations. Hopefully my caveat that I'm not a criminal lawyer will mitigate against me. Not my specialist subject. I'll be very interested to discuss that aspect of where things have got wrong. And if I have got it wrong, I apologise. Much more focused on the civil side. And a question about common interest privilege. In-house lawyer at a non-departmental public body, would common interest privilege generally apply to legal advice, even if shared with our sponsor department? Don't know. We need to look at it. Interesting question. Quite possibly is the answer. And finally, a question: does privilege pass to a trustee in bankruptcy? Again, I'd have to check, but I'm pretty sure it does, and that's one of the successors in title that I mentioned. That concludes today's talk. Thank you so much for attending, and I hope you found it useful. Thanks very much.